All right, let's talk evidence. Not the CSI in America type, the actual law of evidence in England and Wales. What the court will let you use, how you can use it, and what actually matters. Think of evidence law as the rulebook for proving your case, whether you're suing someone, defending yourself, or just not trying to get flattened in a civil claim. Evidence is everything. In civil cases, a lot of the structure comes from the civil procedure rules, especially Part 31. And here's something students always forget. The judge is basically the stage manager. They decide what evidence comes in, how it's presented, and even how many witnesses, especially experts, you get to call. Courts deal with all sorts of material, witness statements, documents, expert opinions, even hearsay, but everything has to serve one big purpose, the overriding objective. Translation, keep the process fair, efficient, and not ridiculously expensive or time-wasting. Two key concepts you have to understand: relevance and weight. Relevance, does this help prove or disprove something important? Weight, okay, but how convincing is it? Even if evidence is relevant, the court can still refuse it if it wastes time, increases costs, or basically adds nothing useful. Now, who has to prove what? That's the burden in standard of proof. Normally, the claimant carries the burden, and the standard in civil cases is the balance of probabilities, more likely than not. Sometimes the law shifts the burden. For example, under the Consumer Credit Act 1974, the lender must prove the agreement isn't unfair. And parties can even agree in advance who has to prove what. Very useful in commercial contracts. Evidence comes in many forms. Documents, emails, contracts, letters, huge in civil litigation. They must be disclosed before trial under CPR Part 31. Witness statements. Someone writes what they know, signs it, and may show up in court for questions. Expert evidence, allowed only if the court approves it. Experts must be independent and owe their duty to the court, not the person paying them. Hearsay. Yes, it's allowed in civil cases thanks to the Civil Evidence Act 1995, but judges will always check how reliable it really is. Opinion evidence. Usually not allowed unless you're an approved expert or it's something an ordinary witness can genuinely help with. And of course, ethics. Lawyers and experts have strict rules. You can't tamper with evidence, influence witnesses, hide documents, or pull dodgy moves. The consequences are career-ending levels of serious. So, here's the bottom line. Evidence law isn't about throwing everything at the judge and hoping something sticks. It's about knowing what counts, who must prove it, and how to present it in a fair and efficient way.